The Insurance Brokers Podcast is brought to you by Sarah Myerscough of Boston Tullis.
Welcome to the Insurance Brokers Podcast with your host, Sarah Myerscough. This business podcast is for ambitious brokers determined to grow their business. Our guests are highly experienced industry experts and innovators. This is the place to leverage their success, learn how to break through barriers to growth, and discover a community of support and ideas whilst growing your business.
Good morning, Dave. Thank you so much for joining me today on the Insurance Brokers Podcast. It's great to have you here.
Thank you very much. Good morning to you.
Good morning, Steve. Thank you also for joining us on the podcast this morning. It's fabulous to have you here.
Thanks. It's lovely to be here.
Do you want to just give us a bit of an overview about who you are and your role within Miller?
Yeah, my name's Steve Cox. I'm head of the UK construction team at Miller's. Relatively new team. I've only been here for the last 3 or 4 months. My experience is I've been in the insurance broking market for 40 years, handling contractors, subcontractors and many project insurances. I've also been the insurance broker for a train operating company and indeed have worked for Network Rail on accounts.
Fabulous. Well, I think I'm really looking forward to the expertise both of you have in the conversation we're about to have. So, Dave, we're going to have quite a technical discussion today, which I'm quite excited about and have already learned a huge amount from you. I wonder if you would just give us a quick overview about who you are and what you do at Miller Insurance, and then we can crack on with the technical stuff.
Of course. My name's Dave Cahill. I'm the head of client development at Miller's construction practice. I've been an insurance practitioner for over 30 years, working for both clients in the construction industry and also for London market brokers. I've been at Miller for about a year, just over a year, where we are developing a new retail construction practice.
And that brings us to this particular topic, which I'm going to explain, and then you're going to tell me if I've got it right. So
Absolutely.
one of the things that is happening, as I understand it, is there's an awful lot of land running next to railway infrastructures that is being redeveloped in a number of ways. And that causes some quite complicated liability issues that there's a bit of a historical movement across legal case law and how it's been dealt with in terms of claims. And I think it's quite a niche area, but it's very, very relevant to the construction market and construction brokers. So I wonder if you could give us kind of the starting point, and we can have a bit of a legal lesson as well in terms of the tort of negligence, etc.
Absolutely, no problem. So I think the starting point for this discussion really is about an incident, a loss that occurred back in 2005, where Tesco was having a new supermarket built at Gerrard's Cross in Buckinghamshire, and it crossed over the Chiltern Railway line that runs between Birmingham and Marylebone, as well as other places. The supermarket car park was being built over the line, and a tunnel was being created so that the line could continue to run underneath the car park, and this collapsed. This tunnel collapsed onto the railway line, like I say, in 2005. Fortunately, no one was hurt, but there was a significant amount of damage, and it also prevented the railway line from operating for about, it was several months anyway.
And it's quite critical to this, isn't it, that the railway line was owned by Network Rail, and Chiltern Railways separate from that, but used the infrastructure for their sort of business, I suppose. That's quite a critical part to this.
That's a really important part. Thanks for reminding me. So Network Rail owned the rail infrastructure, but Chiltern Railways was the train operating company, and they have the right to use the infrastructure under a track access agreement. So, in common law or in the tort of negligence, liabilities exist normally where one party causes a loss to a third party, and that loss is foreseeable. And the test for foreseeability the courts normally apply in the tort of negligence is where there's either some form of damage or injury. Now, in this case, the damage had occurred to Network Rail's property, but Chiltern Railways had suffered a significant loss of use or business interruption to their business, although none of their property, none of their rolling stock, for example, had been damaged in the loss. Now, Chiltern Railways were wise enough to foresee this potential situation, and in advance of the loss they had requested that Tesco provide an indemnity agreement whereby Tesco would be liable for any losses caused to Chiltern Railways arising out of the building project. So Chiltern Railway brought a claim under this indemnity agreement against Tesco, and Tesco accepted that they were liable under the agreement and sought to recover the claim, the damages that they were obliged to make under the agreement. They sought to recover them from their public liability insurers. The public liability insurance policy that they had taken out included a contractual liability provision, and it was Tesco's argument that, albeit this was not a tortious liability, solely a contractual liability, they argued that the insurer was bound to reimburse them by virtue of this contractual liability extension. The insurer felt differently, and the matter went to court, and it was eventually decided on appeal that the insurer was not liable under the contractual liability extension, and that particular policy provision only provided for contractual liabilities that were also coexistent in tort. So if there was a tortious or a liability in negligence or in common law for injury or damage, the contractual liability extension also indemnified for that, but only where there was this coextensive liability in both tort and in contract. So that claim was declined by the insurers, and it set some waves out across the insurance market, particularly in the construction industry and the property development industry, where these liabilities, frequently exist. If we fast forward to the current day, you mentioned quite rightly earlier that there is a lot of property development going on adjacent to transport infrastructure, particularly for Transport for London, where they've made a lot of their property sites available for residential development. But it's standard practice as well for Network Rail, where you operate or you're intending to carry out construction activities close to railway infrastructure. They insist that you provide an indemnity under what's called an asset protection agreement, and this does very much the same thing that the agreement did between Chiltern Railways and Tesco. It says any liability arising from any loss arising from the project that's been carried out, the building work, whether the developer or the contractor has been negligent or not, whatever liability arises, then that party must indemnify Network Rail for its losses.
And what we're really talking about here is if you are unaware of this type of sort of legal development for these type of projects, and you are the development party, you're liable and you really want to be able to claim that back from your insurers, and you won't be able to unless you are aware of this and have put the relevant insurance product in place, which does now exist as a result
Yes.
of these cases.
Absolutely. Some of the liabilities that arise out of these agreements will be covered by normal third-party liability insurance. So if something collapses onto the line, or if there is some type of physical damage loss. However, if it's what we call non-damage events, so there's no damage to Network Rail's infrastructure, or it's an obstruction, or let's say the line cannot open because it's a dangerous situation, even though the line is not technically speaking blocked, then in those situations, in order to be indemnified, you'd need to take out a different type of insurance, what we call contractual financial loss insurance, which has quite a limited marketplace. So your point is absolutely valid. First of all, you have to identify that there is an issue here, which not everyone will be able to do. And secondly, you need to know that there is a specific product which is able to remedy that.
I think that's really helpful. So, Dave, can I just sum up what I think you've told me? Just because I think it's a really interesting topic, but it's also, it brings in quite a lot of legal stuff. And I think it's really important for those people working in these on these projects, either client or brokers, that this is, you know, forefront of the mind when they're looking at these risks. So I think what you've told me is the way that you, long time ago, indemnify one of these type of losses where there is a project development next to a railway and there is some form of damage is traditionally been common law, and we're looking at the tort of negligence. There's some limitations there because of foreseeability and causation, and generally common law doesn't indemnify against pure economic loss. It is where there is damage or injury. So the way that kind of developed was to bring the indemnity into a contract, whereby you're saying you have a contractual obligation to cover me for any losses that occur here. And the major case that happened there was this Tesco's Chiltern Railway, and the pivotal point here was that the damage was sustained by Network Rail, and the business interruption or the pure economic loss was sustained by Chiltern Railway. And the courts found for the insurers and said you're not liable to pay for this claim, which essentially meant that I suppose that Tesco's had to pay out of their own back pocket, because you cannot, these type of third-party liability insurers only cover you where it extends from the tort of negligence, and in this case that didn't happen. So what I'm thinking is these type of risks are really bespoke, I suppose, is the way you would look at it, because I imagine if you're building a bridge over a railway, or if you're just developing something that, I don't know, maybe is built on sand, I don't know, there's lots of different risks. So how do you as the broker sort of go about problem finding and risk assessing to be able to provide the information that the underwriter needs to make sure that this is watertight for that particular client? What sort of areas do you look at? What's really important?
Well, the first place obviously we'd start is with the contract and the asset protection agreement that's in place between Network Rail and the site that we're working for. We'd look into that, check out the requirements of it. As we've probably explained already, there are two aspects to this: the damage liability, damage that flows from a liability incident, the liability that flows from a damage incident to the track and the users, and the second, which is non-damage, causing the track not to be available. The damage aspect is covered by the standard third-party liability covers, and the non-damage part is what's protected by the contractual financial loss policies that are now available in the market. To pick an example, we had a building in South London being built, had a building in South London which was next to an operational railway line where they were having to change the cladding, and we looked at that project, found that they were subject to an asset protection agreement and that there was an exposure to the rail line from non-damage incidents as well as from damage, with the scaffolding that was going up around the outside of the building being particularly onerous in respect of a potential non-damage accident affecting the railway line. If that scaffolding had become unsafe in any way, the trains wouldn't have been able to operate. We collected information around that project, values, period of risk, and the vicinity of the building to the tracks, and we presented that to the insurers that were available to us, which isn't very many, and obtained an indication of price to provide a liability protecting them from the non-damage as well as the damage aspects.
Is you've just touched on that this contractual liability insurance is quite a niche product, and as I understand it, there's not a huge amount of capacity out there. Is that right?
No, it is a niche product with probably only 2 or 3 people who have the capability to lead it, and probably again only one of those is the sort of what we'd call a prime lead market at primary level for risks or for clients with whom they don't already have an existing connection. So yes, a very small market. Capacity-wise, whilst the damage aspect of liability or liability flowing from a damage incident might be several hundreds of millions, the non-damage equivalent is far less. I've seen a placement with a total cover of 80 million, and I reckon we had approached every insurer that had the ability to underwrite it at that time.
So it's quite, you really need to know your stuff when you're talking about this kind of a risk.
Absolutely. And you need to know that whilst the Office of Road and Rail suggest a limit of 155 million is what needs to be put in place around that rail exposure, that actually you can't cover that full required limit in respect of non-damage contractual financial loss, but you can in respect of those damage incidents.
What might be quite interesting for me, because I'm learning a huge amount from you guys today, so thank you, is the sort of standard risks that I can think of, and you've mentioned a bridge falling down. I think in a previous conversation, Dave, you mentioned smoke. And can you give me some examples of the types of claims where this has been really either missed or important to the longevity of that particular business?
So we got some examples that have been given to us of non-damage disruption that's been experienced. There's a railway station that had to be evacuated and trains ordered to stop when builders found an unexploded World War II bomb in February 2019. Trains have been delayed and cancelled after an exclusion zone was extended around Air Station, again due to an unsafe hotel in August of 2018. There's King's Cross Station in London, which had to be closed after a fire at a nearby building site, raised concerns over 4 gas cylinders on the site that could explode. That was back in 2006. And there are a number of times where we've seen unexploded ordnance turn up on building sites across, particularly in London, around sites where rail has been impacted because of those discoveries, and that can range from obviously unexploded ordnance that have been dropped from German airplanes all the way through to just grenades being discovered. Wow,
that's insane.
They're classic examples of cases where the developer or the contractor is not liable, hasn't done anything negligent in placing those munitions of war there. They're just existing. But because they signed a legal agreement that makes them responsible for all incidents arising from the construction project, then they're liable by virtue of the contractual indemnity they've signed.
Wow, it's a minefield of
unexploded ordnance.
Quite literally.
Yeah, absolutely. Having not long ago done my insurance law dip exam and coursework, it kind of rejigged my old world of legal, and I found this kind of thing really, really fascinating. I want to thank you both for coming on and having this conversation with me. If you're happy, I'd like to put your details in the show notes, so if anybody's got any further questions, queries, interested in talking to you about this, you guys are obviously the experts in the area, so if you're happy, I'll do that.
Thank you very much.
Yep, that's fine.
Super. And I just want to thank you very much.
Thank you very much for having us on.
Thanks a lot.
Thanks. Bye-bye.
Thank you for listening to today's episode. If you have enjoyed what you have heard, have any questions or feedback, please leave us a review and we will be sure to get back to you. If you would like further information on how Boston Tullis Group can support your business, or if you would like to join us on an episode, please do not hesitate to contact us.